Hello everyone, I'm Yazan Ibrahim, or as some of you might know me, Yazan Abu Ghosh. Today we're going to dive into a fascinating and essential topic, Fraud Examiner Section 2 Law 2.11. Testifying today's deep dive into the world of testifying, whether you're an aspiring fraud investigator, a business owner, or simply curious about how organizations manage their finances, or if you are auditor, this journey will shed light on the often complex systems that drive decision making. Have you ever wondered how evidence is presented in court? It's not as straightforward as it may seem in movies. The legal systems of the world, from adversarial courtrooms to inquisitorial panels, treat testimony differently, and the role of professionals like fraud examiners, accountants, and auditors plays a crucial part. In this video, we'll journey through the foundations of legal testimony, dive into the differences between these systems, and explore the key roles of witnesses. Whether they're lay witnesses recounting first-hand events or expert witnesses unpacking complex technical issues. Let's break it all down and unravel the intricate rules and responsibilities of testifying. Testifying, an overview. At its core, testimonial evidence consists of statements made during a trial, hearing, or deposition. But not all testimony is treated equally. It depends on the type of witness and the nature of their statement, as governed by legal standards. Now, let's imagine we're walking into an adversarial courtroom, a bustling space where the drama of direct testimony and cross-examination unfolds. Here, the parties, the prosecution and defense, play a leading role in uncovering and presenting evidence. It's a system that gives significant weight to oral testimony and the art of persuasion. Contrast this with inquisitorial systems, where judges take center stage. Picture a methodical, evidence-driven inquiry, a judge overseeing interrogations and evaluations. The emphasis here is on accuracy, less on crafting a dramatic narrative. Cross-examinations? Rare. Instead, the judge seeks direct answers to cut through the noise. While adversarial and inquisitorial systems both aim for justice, they approach evidence discovery in profoundly different ways. The professionals who take the stand. The wheels of justice often rely on the expertise of certified fraud examiners, CFEs, accountants, and auditors. They bring insight into cases involving fraud, embezzlement, or tax irregularities. But what exactly do they contribute during testimony? Sometimes it's first-hand experience, categorized as lay testimony, while other times their expertise elevates them to expert witnesses, offering professional opinions. Let's go deeper into each type. Lay testimony. Imagine you've been investigating a financial fraud case. As a lay witness, your role is to recount what you observed, providing factual testimony from your direct experience. It's like being a puzzle piece that helps the court see the bigger picture. Think of a fraud examiner presenting findings from an investigation, facts, calculations, or observations, meticulously prepared to ensure they're both admissible and reliable. Preparation is key. Lay witnesses must meet competency requirements, encompassing the ability to observe, accurately recall events, and clearly communicate their testimony. They provide evidence sourced from observations, research, or even visual aids like charts. Courts often allow summaries for complex evidence, but original documentation should always be available for review, a critical safeguard for accuracy. Even so, a lay witness's opinions are limited. They must be based on personal perceptions and restricted to helping the court understand events or facts, such as describing a person's conduct or emotional state. Anything technical or specialized falls outside their purview. Expert testimony. And now zoom out to the world of expert witnesses, the individuals with specialized knowledge who can shed light on complex, often bewildering issues. Think of them as translators for the court, demystifying technical jargon and guiding the fact finders through intricate evidence. Take, for example, a fraud investigator called upon not just to confirm a fraud occurred, but to explain how it happened. Expert witnesses must be credible, impartial, and thoroughly knowledgeable in their domain. The court relies on their objectivity as they present well-reasoned conclusions backed by robust methodologies. Attributes like credibility, Analytical precision and independence are not optional, they're essential. Some expert witnesses, like testifying experts, actively participate in courtrooms, while consulting experts stay behind the scenes, advising attorneys where needed. Both roles are crucial, whether it's by adjusting the investigative lens on the fly or scrutinizing the methodologies of opposing experts. To be an effective expert involves more than knowledge. It demands meticulous pretrial preparation, document analysis, and systematic evidence organization. Preparing for the stand, whether lay or expert, witnesses play their part in adversarial and inquisitorial systems. But how they're prepared and even selected differs. In adversarial systems like those in the US, each party introduces and pays its own experts, who are often subjected to rigorous cross-examination. In inquisitorial settings, judges appoint neutral experts from pre-approved lists to ensure impartiality, while opposing counsel in adversarial systems attempts to dismantle credibility, the inquisitorial process, in contrast, relies heavily on judicial oversight, aiming to make expert testimony as fair and objective as possible. For both types of systems, pretrial preparation is critical. Witnesses work alongside attorneys, analyzing documents, reviewing reports, and preparing for courtroom challenges. Experts, for instance, often present detailed reports summarizing their findings. A single misstep here, such as failing to meet legal standards, can result in testimony being excluded entirely. Organized files are a lifeline, and witnesses must avoid including personal notes or speculative lines of inquiry that can easily be exploited during cross-examinations. Becoming a witness, qualifications and challenges. But how does someone become qualified to serve as an expert witness? In adversarial systems, a party must first establish a candidate's qualifications, formal education, professional certifications, experience, and then convince the judge their testimony is both relevant and reliable. Relevance and reliability are tested through rigorous standards. Reliable testimony is fact-based, supported by logical reasoning and validated methodologies. Relevance, on the other hand, ensures the testimony addresses key issues in the case. Experts should have well-documented evidence, backed by references like industry journals. In inquisitorial systems, the qualification process is often more standardized, with experts appointed from pre-selected lists. Here, frequent testimony doesn't carry the risk of bias as it might in adversarial systems. Legal testimony is not just about words. It's about clarity, precision, and trustworthiness. Whether it's a lay witness recounting their observations or an expert translating technical data into accessible explanations, the goal remains the same: to present evidence the court can rely on to pursue justice. The distinctions between adversarial and inquisitorial systems and the demanding preparation required highlight just how nuanced this process can be. By understanding the inner workings of testimonial evidence, we grasp not only its value in courtrooms, but the role it plays in shaping outcomes, uncovering truths, and ensuring fairness. The next time you hear a courtroom testimony, perhaps you'll think a little differently about the preparation, expertise, and systems underlying the words. Imagine stepping into the world of the courtroom, where truth, logic, and meticulous preparation reign supreme. Whether it's a civil case wrapping up in a settlement or a criminal case resolved through a plea bargain, the pivotal role of witness testimony often determines the outcome. Yet these testimonies are rarely spontaneous bursts of insight. They are carefully constructed, rehearsed, and scrutinized. Today we'll embark on a journey into the art and science of testifying, an exploration of depositions, courtroom dynamics, and the critical do's and don'ts for witnesses. By the end, you'll understand not only what it takes to be a compelling witness, but also how subtle details, like a twitch of a finger or the timbre of a voice, can make or break one's credibility. To begin, let's explore the concept of depositions, the cornerstone of evidence gathering. A deposition is essentially a sworn testimony taken out of court during the discovery phase. Think of it as the groundwork for the courtroom drama later on. The purpose? Well, depositions are a multi-purpose tool. They are used to gather and preserve evidence, lock witnesses into their statements, and assess whether their credibility will hold up under pressure. It's like unearthing a puzzle piece that, when combined with others, can reveal the larger picture of the case. Here's something fundamental. While witnesses are required to testify, there's a level of flexibility. The place, the time, it's negotiable as long as both parties agree. And these depositions, they might be recorded in several ways. A court reporter producing verbatim transcripts, a camera capturing every glance and furrow of the brow, or even a simple voice recorder. But this is where the details matter. Once the transcript is available, witnesses must review and correct any errors without delay. It's not just about clarifying inaccuracies, it's about ensuring your words won't be used against you unfairly later on. Preparation for a deposition is like gearing up for a marathon. It goes beyond knowing your report inside out, understanding calculations, methodologies, and conclusions. Witnesses must ensure all related evidence, from graphs to reports, is organized and readily available. Oh, and there's no winging it here. The sequence and strategy of your testimony should be synchronized with legal counsel beforehand. Here's a major tip. If a witness's opinion evolves after their deposition, informing counsel immediately is non-negotiable. Changes like these can affect the entire case pathway. Now picture this, the day of testimony arrives. You step into the room. The eyes of attorneys, judges, and perhaps a jury fall on you. How do you make the right first impression? It starts with your appearance, conservative business attire, poised posture, and an air of professionalism. Beyond these surface details lies an even more important principle: composure. Nervous habits, like tapping a pen or shifting in your chair, might seem harmless, but can subtly undermine your credibility. The key is to exude confidence without arrogance, professionalism without coldness. Let's dive deeper into what sets exceptional witnesses apart, starting with the golden rules, the do's and don'ts of testimony. Let's begin with what to do. Confidence is your ally, as is politeness. Answer questions honestly, but keep your language simple, especially when explaining complex ideas. Rehearsing beforehand isn't just encouraged, it's essential. Remember, a well-prepared witness can walk the fine line between spontaneous and rehearsed, articulating their testimony naturally while staying rooted in the facts. Visual aids, consider them your secret weapon, capable of translating dense data into digestible insights. But equally important is what not to do. Humor or sarcasm might seem like an attempt to disarm tension, but in a courtroom setting, they're landmines best avoided. Similarly, excessive movements, from fidgeting to deliberately exaggerated gestures, can distract from the substance of your testimony. Perhaps the most critical pitfall is guessing. If you don't know the answer to a question, state it clearly. Guessing or inflating responses can backfire, eroding trust in your credibility. And here's a practical tip. Steer clear of volunteering information beyond the question. Courtrooms thrive on precision, not oversharing. Straying from this principle is like opening Pandora's box. It can lead you into unexpected and often perilous territories. Now, what happens when your testimony is subjected to the intense scrutiny of cross-examination? This is where pressure runs high. Here, less is often more. Respond with deliberate brevity, sticking to yes or no when possible, and avoid the temptation to elaborate unnecessarily. It's not about evading the questions, but maintaining control. If you find yourself confused by a question, don't guess. Request clarification or rephrasing. The most critical advice for cross-examination: do not take it personally. Staying composed, regardless of provocations, is paramount. While tactics to discredit a witness can be emotionally charged, understanding these strategies can make them less daunting. Opposing counsel may attempt to highlight inconsistencies, insinuate biases, or even exploit subtle gestures to challenge your professionalism. However, preparation is the great equalizer. Familiarizing yourself with reports, anticipating the line of questioning, and staying grounded in the evidence can safeguard your credibility. With that grounding, let's touch on the unique considerations for expert witnesses. Unlike lay witnesses who testify based on first-hand experiences, experts are like beacons of specialized knowledge. In adversarial legal systems, like those in the US or UK, experts are often retained by one side, working closely with counsel to craft a testimony that aligns with their findings. But here's a critical reminder. Objectivity is the cornerstone of their role. Experts must present facts and opinions with conviction, steering clear of personal bias. The aim isn't to sway emotions, but to lend clarity to complex technical aspects of the case. In inquisitorial systems, the style prominent in many European judicial settings, experts are often appointed by the court or judge. Their scope, activities, and access to evidence are tightly regulated. Whether adversarial or inquisitorial, reliance on expert reports and visual aids, like diagrams or annotated documents, can transform dense analyses into compelling narratives. And finally, for fraud examiners and forensic specialists, the rules are even more nuanced. These professionals inhabit a space where ethics and objectivity intertwine. For example, the Association of Certified Fraud Examiners, ACFE, strictly prohibits offering opinions on guilt or innocence. Their role isn't to judge, but to provide evidence that paints a clear and objective picture. Similarly, understanding jurisdictional nuances, like immunity from lawsuits for expert testimony, can further shape their approach. At the core of every great testimony lies preparation, composure, and clarity. By embracing these principles, witnesses can navigate the courtroom with confidence and poise, ensuring their testimony holds weight and contributes meaningfully to the pursuit of truth. Thank you for watching, and as always, continue learning. Stay curious, and we'll see you next video, Section 3 Investigation.